Call the fourth case on this morning's docket, case number 118226, in the matter of Kenneth Genuek. I don't see anybody approaching as opposing counsel, which I assume would be Mr. Genuek because he's appearing, according to our docket, pro se. Is Kenneth Genuek in the courtroom? Nobody has responded. He apparently is not here. During your presentation, counsel, would you be able to tell us what sort of notice, if any, was provided to him that he was ordered to appear today?
Yes, Your Honor.
Very well. Thank you.
May it please the court. Danielle Hall, appearing on behalf of the disciplinary administrator. This case is an original attorney disciplinary action involving Kenneth Genuek. Mr. Genuek was admitted to practice law in Kansas in 2007. He was subsequently admitted to practice law in Missouri in 2008. In September of 2013, Mr. Genuek's Kansas license was administratively suspended for the failure to comply with annual registration requirements as well as annual CLE requirements. However, Mr. Genuek never applied for reinstatement of that Kansas license, but in January of 2015, Mr. Genuek entered his appearance in a Wyandotte County sync action in which he used his Kansas registration number. That same day, he appeared in front of Judge Cahill in that sync matter and subsequently appeared for a hearing in that matter in April. Then in July of 2015, Judge Cahill received notice from staff that Mr. Genuek was potentially administratively suspended in Kansas. At that time, Judge Cahill began to investigate the matter, in which he went to Mr. Genuek's website to gain some contact information and noticed some language that indicated that he was potentially licensed in Kansas and Missouri and serving clients in Kansas and Missouri. In July of 2015, that same day, there was a hearing on the matter for that sync action in which Mr. Genuek appeared. At that time, Judge Cahill asked, do you have a Kansas license? Instead of responding to that question, Mr. Genuek stated that he had the authority to appear under KRPC 5.5C2 because he was planning on filing a Missouri paternity action involving the father that he was representing in the sync action. Judge Cahill indicated that he didn't believe that KRPC 5.5C2 was applicable and asked Mr. Genuek to step away from counsel table and subsequently filed the complaint in our office. Now, after this complaint was filed, our office received notification that Mr. Genuek was indefinitely suspended for a period of time in Missouri on his Missouri license for violation of Missouri Rules of Professional Conduct 1.3 and 1.4. We did file a formal complaint alleging several rule violations in which we filed in April of 2017. We were uncertain whether or not Mr. Genuek would receive the formal complaint and notice of hearing, so as a result, in order to comply with Supreme Court Rule 215A, we sent one of our investigators to personally serve Mr. Genuek at his place of business. After this service of process occurred, Mr. Genuek failed to file an answer to the formal complaint. In addition, he failed to appear for the panel hearing. Now, at the panel hearing, the panel found several rule violations, particularly Rule 5.5, the unauthorized practice of law, KRPC 7.1, making a false or misleading statement about the lawyer's services in regards to the information that was contained on Mr. Genuek's website. 8.3 and Supreme Court Rule 207C for failing to report the Missouri misconduct. 8.4D for engaging in conduct prejudicial to the administration of justice by entering his appearance on a suspended license. 208C for failing to update his registration address, and 211B for failing to file an answer to the formal complaint. The hearing panel also found several aggravating factors present, prior discipline being the Missouri suspension, multiple offenses that were apparent in this case, a bad faith obstruction for failing to appear and adhere to disciplinary proceedings, a refusal to acknowledge the wrongful nature of his conduct, as well as Mr. Jenowick had substantial experience in the practice of law, being admitted in Kansas in 2007. The hearing panel found no mitigating factors present at that time. Now, at the hearing, the disciplinary administrator made the recommendation of indefinite suspension. Ultimately, the hearing panel agreed with that and also recommended indefinite suspension. Now, Your Honors, prior to today's proceedings, I did look on the court's website to see whether or not Mr. Jenowick received notice of today's proceedings. I wasn't positive that he did, so as a result, on January 23rd, 2018, I sent the same investigator who served Mr. Jenowick the formal complaint in the panel hearing to take Mr. Jenowick a copy of the letter of appearance from the clerk's office to Mr. Jenowick. On January 23rd, 2018, that investigator was able to hand Mr. Jenowick personally that letter of appearance. And at that time, Mr. Jenowick indicated that he would not intend to show up to today's proceedings. I do also think it's important to make the court aware that I did receive a phone call from Mr. Jenowick yesterday. He indicated to me that he would not be appearing today and indicated the reason being that, quite frankly, he currently had a job, he just received a promotion, and he had no intent on practicing law ever again. At that time, he did indicate he wanted to express that he was not trying to be disrespectful to this court, but simply that he didn't feel that he could actually take the time to appear here today, especially considering he had no intent to practice law again. Now, despite this explanation, I do think it is important to bring to the court's attention Kansas case In re Barker, and that's citation 302 Can 156 2015. In that case, this court stated, when a respondent fails to appear before the court when facing recommendations of indefinite suspension, a sanction greater than that recommended by the disciplinary administrator or panel, even up to disbarment, may be warranted. I did give Mr. Jenowick notice that if he failed to appear today that the court could consider disbarment. As a result, I do submit to the court that his lack of appearance today should be seen as an additional aggravating factor despite his explanation as to why he wouldn't appear. And while my original recommendation was for indefinite suspension, I am respectfully requesting that the court issue disbarment for Mr. Jenowick.
Just so I'm clear, counsel, in this conversation yesterday, you said, if you don't show up, the court can consider disbarment, and he said, I'm not going to contest this basically because I do not intend to practice law. Is that a fair characterization?
That is a fair characterization.
All right. Any other questions? All right. Thank you, counsel.
Thank you.
Court will take this matter under advisement.